Hello, everyone. My name is Aaron Gelb, and I'd like to welcome you all to Conn, Maciel, Carey's August 2020 webinar on employee discipline, OSHA, and labor and employment issues. This being August, this is our 8th webinar of the year for the firm's OSHA practice group, as well as the labor and employment practice group. While each group typically hosts its own webinar, as many of you probably know, we're joining forces this month for a joint webinar. A crossover episode, if you will, like when NBC's Chicago Med is a story that crosses into an episode of Chicago Fire. Or for you comic book fans, I'll modestly say it's like DC's Justice League combining with Marvel's Avengers, because we all know that you view your lawyers like superheroes, right? I hope. I am particularly excited this month because we not only have assembled what I think is a really good group of CMC lawyers, but a special guest who I'm really excited to have join us, Rich Fairfax, formerly of OSHA, and someone who really needs no introduction, but he'll introduce himself in a minute. We'll return to separate webinars next month with an OSHA webinar on privileged safety audits and an L&E webinar focused on the National Labor Relations Board. Back to today, as I mentioned, we'll be focused on employee discipline, a topic that is important to running a compliant organization, whether your focus is on employee health and safety, EEO, anti-discrimination compliance, or labor relations. So let's dive in and get started. We'll begin with brief introductions since we know you're here for content and not to hear us talk about ourselves at length. Again, my name is Aaron Gelb. I'm a partner in the firm's both in the OSHA Workplace Safety Group as well as the Employment Group. I'm here in Chicago, formerly downtown in the Loop, currently in my home office up near Wrigley Field. I focus the majority of my practice on representing employers in OSHA proceedings, both in inspections, contesting citations, helping with the development of safety and health policies and procedures, conducting privileged audits. I've been out in the field a ton, despite this pandemic, managing all sorts of in-person OSHA inspections, dealing with traditional safety and health issues, as well as just a very broad range of COVID complaints and COVID fatality inspections. I also have an extensive amount of primarily federal jury trial experience on the employment side, and have tried cases across the country over my 25 plus year career. As you can see from the bio slide, I attended college here in Chicago at the University of Chicago and law school at the University of Texas. So with that, I'll turn it over to my colleagues to introduce themselves, and then we'll get started.
Thanks, Aaron. I'm Megan Shaked. I work in the Conn, Maciel, Carey, San Francisco office, though currently in my home office in Oakland, California. I'm also a member of both the workplace safety and employment practices at CMC. And through the OSHA work, I represent employers during inspections and investigations, primarily those conducted by California OSHA. And on the labor and employment side, I represent and advise employers on all aspects of the employment relationship, including discipline, which we're talking about today. I review policies and handbooks and advise employers on numerous issues, as well as handle state and federal litigation also in California.
Thanks, Megan. Hi, everybody. I'm Mark Trapp. I work here in Chicago, normally with Aaron, but like he said, he's working from home. I was working from home for some time, but I'm back downtown generally. I feel like the last man on earth, that old movie, or the one I liked better, I Am Legend with Will Smith. But yeah, I'm down here mostly by myself. I have a 20-year career representing management, dealing with labor unions, collective bargaining, grievances, arbitrations, and all sorts of employment litigation. One little specialty that I've picked up is dealing with multi-employer pension withdrawal liability. But today we'll be focusing on labor unions and discipline in the labor union environment.
Thanks, Mark. And I'll just kind of pre-introduce our next speaker, Rich Fairfax. I'll let Rich really introduce himself, but I've been working very closely with Rich on a number of matters, really important kind of mission critical safety issues for a number of clients. And when we were planning for and preparing for this presentation, I could think of nobody better to really talk about and join me for the discussion, the OSHA side of these issues. So Rich, with that, I'll let you introduce yourself.
All right, thanks, Aaron. And also thank you for inviting me to join you on this webinar. I appreciate it. My bio's up there. You know, before OSHA, I was actually I worked through the Pipe Fitters Union, and I was a pipe fitter and welder back in a long time ago, back in the 1960s. So that sort of dates me, I guess. I joined OSHA in, God, when did I join OSHA? 1977 is when I joined OSHA, just a few years after the OSHA Act. I was an industrial hygiene compliance officer. I was the director of enforcement programs for about 13 years. And then I was the deputy assistant secretary, where in reality, most of OSHA ended up reporting to me. I retired in 2013, and I've been working for ORC and a few other companies, you know, pretty much part-time since then. So that kind of takes my career up about, you know, 40 plus years in the health and safety arena. And we'll be talking, I guess, later about the Fairfax memo. There's actually a lot of Fairfax memos. So, you know, you know, there's a lot of them, but we're going to talk about one in particular dealing with incentive programs.
Yeah, I think that's the one that at least from our perspective is probably the most, maybe it's the most recent or the one that drew the most attention. And I can still remember, I think it came out short before a meeting of the American Bar Association's OSH committee, and it was I still remember it to this day being kind of the talk of the meeting that week. So we're excited to have you here to join us and talk about that memo, because I think many of the issues that were addressed in there, you know, still come up today. We still hear one of the issues that drew a lot of focus, for good or for bad, was the concern about holding pizza parties to celebrate the lack of injury and illness, or lack of reported injuries or illnesses. And I still hear that a fair amount. So let's jump to the agenda, just to orient everybody where we're going to head today. So I'm going to start off talking and joined by Rich to go over two OSHA topics: the UnPreventable employee misconduct defense, which is the favorite of the defense bar and many corporations, and we'll get into how that works, kind of some best practices or tips or suggestions in terms of what you need to know. It doesn't work simply by raising it. You actually have to have the evidence and the facts to back it up. Then we'll get into talking about safety incentive and disincentive policies, which is what Rich is referring to with the one Fairfax memo, and those policies obviously tie into discipline, because in many cases they may be the basis for discipline, or lack of compliance with them results in discipline. Then Megan will get into talking about discipline and discrimination, how it relates to discrimination claims. Similarly, I think just as you're building a case for employee misconduct in the OSH context, obviously discipline is quite often the basis for a termination, and good discipline makes for a much more defensible case. Then we'll talk about conducting effective investigations, as investigations obviously often lead to discipline. And then Mark will bring us home with a review of discipline in the unionized workplace, which obviously is anyone who has unionized a union or more than one union in your workplace knows that it can be an entirely different kettle of fish. So with that, jumping over to discipline and the employee misconduct defense, and I'll move through some of these slides somewhat quickly. We're focused really on, if you think about citations that from an employer's view are caused by either affirmative employee misconduct or perhaps lack of action by an employee, which still in many ways can be misconduct. That there are really two defenses that we raise, or there are two primary defenses. There are many other defenses that employers raise and that we raise on behalf of our clients when OSHA issues citations. And if you kind of really want to dig into that, you can listen to a recording of our, I think it was last fall webinar that we did on responding to kind of post-citation strategies, both from settlement as well as contesting citations. But for today, what I'm going to focus on primarily are two defenses. One, which is the lack of employer knowledge, and the other is unpreventable employee misconduct. So these are two very common defenses. To establish a violation generally, so this is from OSHA's standpoint, what does OSHA have to do first? And if you read any opinions or any decisions when employers contest and take a matter through trial, typically the judge, the administrative law judge, is going to go through each element of this defense in his or her analysis. The first is, does the standard even apply? And obviously that's an argument that we make from time to time. Hey, OSHA cited the wrong standard. The standard doesn't apply here. It could be raised in the context of the employer was cited for a violation of the general industry standard, but when in fact this is actually this was construction work, so they've cited the wrong standard. Or within either the general industry section or the construction section, hey, there's actually a different standard that applies more directly, or this one doesn't apply. The next element that OSHA has to establish is that the employer failed to comply with the cited standard. Obviously that's fairly basic aspect of OSHA having to prove their case. But even if they can establish a lack of compliance, the agency then still has to establish that the employees had access or exposure to the violative condition. So you can see this in many number of different contexts. For example, in a machine guarding citation, we might argue that yes, this machine wasn't appropriately guarded, but there was no exposure for any variety of reasons. A whole host of arguments that can be made as far as the lack of exposure to the alleged violative condition. And then last but not least, the employer had knowledge of the violative condition. This is also a very common, very important element that OSHA has to establish. So again, as I run through this, you hear me talking about this is OSHA's burden. They have to establish all of these things. So these are, you think about when the inspector is on site conducting his or her inspection, these are the different aspects that they are looking for: evidence, documentation, photographs, through interviews, to establish all of these different aspects. So when they issue a citation, they're confident, or they believe that they can sustain that if it's challenged. So moving to the next slide, how does OSHA establish the employer knowledge prong? There are two different ways that the agency can do that. The first, obviously, is actual or direct knowledge. So they are aware of the situation, or they've seen through operations, they see this dangerous condition, or they see employees that are working in the area. So using my guarding example, they see somebody working away from the expected or assigned workstation, closer to the unguarded nip point or pinch point. So they can't establish, so the employer would not be able to refute the allegation by saying, well, no, there was no exposure because no one works there. Perhaps the COSHO has a picture of somebody working in the area. Through interviews, they can establish people, either through management interviews that employees were seen in the area, or the employees themselves saying that, no, I'm regularly in that area, and managers see me there or speak to me there while I'm working in that area. The other, and it can be a little bit more of a challenge, would be the agency establishes that the employer, through the exercise of reasonable diligence, should have known of the violative condition. So this is essentially kind of the counter to the ostrich sticking his head in the sand. You can't just say, because we never checked this area, we never evaluate this process or this procedure, therefore we didn't know. An employer that is reasonably diligent, that is conducting itself in a manner that would be expected of an employer operating this piece of equipment or carrying out this process, should have known or would be expected to know that this violative condition exists. So then moving on to the next slide, just kind of then comparing the knowledge defense versus the misconduct defense. So if you can see on the left-hand column with respect to employer knowledge, as I made very clear the last couple slides, that is OSHA's burden of proof. That means that they have to put on evidence to support each of those elements if the case goes to a hearing, and they're going to be expected to put on testimony or documents to establish and sustain each of those. But it's a single element of proof, meaning if they can establish knowledge through one of those mechanisms, they've carried their burden as to that element. In contrast, when an employer raises misconduct as a defense to the citation, it's referred to as an affirmative defense, which means that the burden shifts to the employer, and the employer has to put into the record evidence to establish the defense of employee misconduct. And as you'll see on the next slide in a second, there are multiple elements of proof. It's not just one piece of evidence or document. So how does an employer establish and prove unpreventable employee misconduct? As I said at the outset, this is a defense that, it's certainly one of the first things that we always look into and we ask about and we try to evaluate when a client comes to us with citations or even in the course of an inspection when it appears to be that this could be a defense that is raised. And it is obviously a viable defense and it's an important one, but it's also one that I think can be, or at least many employers may think that they can assert it reflexively, meaning like, well, something, because there was an accident and we didn't intend it, clearly the employee did something wrong. So if there's this culture of blaming the employee for every accident, every injury, or every illness, you need to take a more nuanced look generally at these proceedings or at these events and really look into and dig into whether you can establish each of these 4 elements that we're going to go through now. So the first one is, has the employer established a work rule that's adequate to prevent the violation? I think of the 4 elements, the 4 boxes that you see on the screen in front of you, the first 2 are probably a little bit easier to establish. The first one being, again, if you have a policy, if you have a written procedure, you've done that. Now, hopefully, it's a well-written procedure. It makes sense. It fits the workplace. It's customized to your operations. It's not just something that you downloaded from the internet and have not kind of customized to the conditions at your facility or your work site. Assuming you've done that, that is not the most difficult box to check. And similarly, the next one, effectively communicating the rule to your employees. However you go about doing that, disseminating paper copies, conducting training. It's usually a combination of the 2. And again, if you have a well-run organization, you've got a good training program in place, you should be able to meet and check off both of these boxes. I think this is similar in many ways to EEO compliance. Hopefully everybody listening has an employer handbook. You've got an EEO policy, you've got a harassment policy in there. Presumably you're training your managers and your employees on anti-harassment and anti-discrimination. So those are the easy boxes to check on that side too. The harder part is what I would call walking the talk. And I think that's where on the health and safety side, we see the next two boxes. So the third being that you've established methods to discover violations of the rule, but did not know about this specific violation. And that's where I wanted to first ask you, Rich, to talk a little bit in your experience, having spent many years at OSHA. What are the sort of systems or approaches that employers can take to effectively and build a case that they've put measures in place to discover these violations?
Sure. These are all 4 of them are really solid, good points. The way a lot of companies do it, and I think this works well, is they have some sort of a self-audit, self-inspection program where they go around and they walk through the facility they observe the work that the people are doing. They observe the rules. They make sure, you know, if you have written programs or you have written procedures, that those are indeed being followed. What I see more times than not, and what I see employers getting in trouble with, is they've got great written programs and they've got really good written procedures. It spells out everything, but they're all off on a shelf somewhere, and they may have communicated the work rules to the employees, but when it comes down to it, over a period of time, you know, shortcuts are taken, and the work as the managers believe is being done, you know, is not being done that way, and they haven't done any sort of evaluations or anything. So when something happens and you have a hazard that employees are exposed to, and OSHA picks up on it, and the employer comes back, or OSHA comes back to the employer with a citation saying you weren't following this, and the employer or an employee gets hurt, and the employer goes back at the employee, and it, you know, it ends up coming back to OSHA that, you know, they didn't know about the work rule. You know, this is the way we've always done it. I mean, there's a whole variety of things that play in. So the key thing is, you know, if you have a program or procedure, then it needs to be followed. If no one's following it, it's either too complicated, you know, for them to follow, and there's too many steps, you know, the work isn't being done the way they think it's being done, or, you know, there's a production issue, or people are trying to get things done and they're skipping certain steps. So you got to have something in writing, you have to document it, and you have to have some sort of walkthroughs, visual observations, self-inspections, maybe a periodic audit or something to pick up on, you know, how it's being done, so these hazards aren't missed and employees know and managers know they need to follow it. Okay.
Yeah. Thank you, Rich. I think that really sums up the views I have as well on this issue. And I when I think back to the informal settlement conferences that I've gone into, well armed with as you said, I mean, I can't hammer home enough the point about documenting. It's one thing it's great if you've got people walking the facility every day that are doing safety observations, you know, you've trained your managers to look for, you know, make sure people are doing this, you know, following this rule or that rule. I had a client where every manager would say, you know, working around high reaches in a warehouse, powered industrial trucks, that they'd always look to see if people were tied off and had their harness and were tied off. Well, that's great, but they didn't have documentation of that. So it's still way better than nothing. We could go in with whether it's a declaration from the manager that they do that, an affidavit, but other clients that have then taken it to the next level, which have, whether it's a paper checklist that every manager is expected to complete every day, or even better yet, in today's app-driven age, where each manager has a tablet or a phone that they are expected every day to open up and in the course of the day look for certain behaviors. If you've got forklifts, you look to see that people are driving in the direction of travel. If it's lockout, tag out, you're making sure that your maintenance people are locking out before they're performing servicing and maintenance. And if you're recording that every day, and then we can go into that informal conference and say to OSHA, no, this is misconduct, and here is what we again, as Rich said, we have not only the policy and the training, but we actually walk that walk and we make sure that people are doing it. You'd be amazed at the number of citations that we can get actually withdrawn when we can make that compelling case. The last element, which is one that in many cases I think is easier said than done, and this is where we tie it into today's topic on discipline, is that the employer has to show that it established effective enforcement of the rule when violations are discovered, and that just means that you're holding people accountable. So whether that is through a written warning, a suspension, a termination. You know, obviously, OSHA often asks in inspections for a copy of your safety discipline policy. Some employers have their own separate safety discipline policy. Others include safety as one of the elements of a general progressive discipline policy. I don't have really strong feelings one way or the other, as long as that safety is in your disciplinary program in some form or fashion. But what you see sometimes is either the quote addressing of violations is it's all oral. You know, we just talk to the employee and there's again no documentation of that, or we keep putting people on a final warning, but we're never firing them. So Rich, I don't know if you have any thoughts kind of on what makes for effective discipline. What would OSHA look for as sort of the discipline that actually has teeth or means something?
Yeah, this is actually a really good point, and I think you hit it right on the head, Aaron. It's just, if you have a disciplinary program, you have to follow it, and you need to have it spelled out. And the most common one, and I will tell you, if OSHA goes in on an inspection and the manager says, well, the employee violated this rule, that's why the guard's off, and so we disciplined him. And then OSHA's going to interview the employee, and he or she will ask the employee, have you ever been disciplined? 9 times out of 10, they're going to say, no, I've never been disciplined. We do this job day in and day out. So again, the key is the documentation. But when you have a situation and you point to the employee and say, yeah, we gave him a verbal warning, or we gave him, a written verbal warning, OSHA's going to want to see it. And OSHA's going to want to look at, do you have some sort of progressive program? I mean, the typical one is a verbal warning, a written warning, a few days off, maybe a couple times with a few days off, and then finally termination. But you have to apply that consistently. I mean, that's kind of the key thing, and that's something OSHA will look for. And I'll just tell you what OSHA finds typically in a lot of cases is if they have a quote unquote really good employee, and that employee violates the safety rule, 9 times out of 10, they're not going to get written up. There's going to be no documentation. And then when you have an employee that is not so good, and they violate the same rule, and then they use that as an excuse to fire the employee files a whistleblower complaint, and their main argument is going to be well, so-and-so violated the same rule, and I was just doing what he or she did, and it was okay for them, but they fired me. So you have to have some sort of program in place, and then you have to follow it. And, it's got to be fair, it's got to be equitable, but it has to be followed, and it has to be documented. You can't just go, well, we gave them a verbal warning. You should, after the manager gives someone a verbal warning, write down the date, write down what you said, write down what the employee did, and put it away so when something happens, you've got a piece of paper to fall back on to point to at OSHA, and then follow the progression. All right?
Yeah, and I think for those employers that are concerned, like, well, we're going to set the wrong tone, or we're going to upset the employees if we start cracking down on this issue or that issue, start with something even like I've seen clients that use kind of, like traffic enforcement, like a safety ticket. So it's not even, it's a prelude to a verbal warning. It's just the first time someone's not wearing their goggles, or you think about it in the context of COVID-19, someone's got their mask not covering their nose. The first instance, it's a safety citation. It's like a little card or something you give to the employee, but as Rich said, you document it. It's in their file. And then the next time that they do it, then they get the verbal, and then you move up the chain, so to speak. So moving just to kind of tie this issue down, because I know we've got a lot to cover, and I want to get into the safety disincentives. Just to tie it all together, really can't emphasize enough. Obviously, pretty much every presentation given by any lawyer in the history of lawyering, at least on the employment side, we talk about documentation being the key, right? And I think that as you see on the slide, I often go into proceedings with OSHA with the expectation that if it's not documented, it didn't happen. I had a conversation with a co-show in the context of an inspection a couple of months ago, COVID inspection, where they were asking about whether the company was compliant with its internal cleaning and sanitation protocols, and I was emphasizing, of course they are. This is a company that's taking it seriously, and his response was trust but verify. So they wanted to see the documentation that the cleaning was actually being done. So same thing with discipline. So make sure if you've got a policy or procedure that's important enough to discipline somebody for not complying with it, make sure it's written, make sure it's readily accessible, both to the employees as well as to the managers that are expected to enforce it. Make sure you've got written records of training, sign-in sheets, agendas, the documentation themselves, the quizzes that might be issued. If you're doing kind of stand down or meetings or pre-shift meetings, toolbox talks, things like that, you have a quick one-page agenda with a sign-in sheet for that as well. I know it creates some additional paperwork, but again, that's just another great tool that we can go into the informal settlement conference or settlement negotiations to show that we've got proof to back up what we're saying. Like I said, also document the audits that you're doing, whether it's a daily audit that managers are charged with or weekly or monthly audits. It's just a lot better if there's some written record of that, as opposed to just something in the owner's calendar. I drove by the work site and I visited it, but there's no record of what he or she was actually looking at or addressing. And then last but not least, again, why we're here today, issue discipline and make sure you're documenting whatever discipline you issue, whether it's a citation or verbal warning or what have you. So that's a quick primer on the unpreventable employee misconduct. Moving on to safety incentive and disincentive policies, as well as the discipline that can come out of those. This really big, while Rich's memo, the famous Fairfax memo, was issued before December 2016, it kind of, I think, came up again when OSHA issued its electronic record keeping rule, and beginning in December of 2016, and hopefully everybody knows this, that employers are required to inform your employees of their right to replace workplace injuries as well as illnesses, inform them that they are free to do that, or they're able to do that free from discrimination or retaliation. As Rich said, you don't want the employee who worked around the unguarded equipment or was engaging in the unsafe behavior every day in full view of employees is not disciplined until they report the injury. I think that I know one example I hear from time to time. The employee who's leaning back in his or her chair at their desk every day. Manager walks by every day. The person's leaning back on 2 of the 4 legs. Then one day they finally flip over, fall, hit their head, taken to the hospital. Then they're disciplined. That can be a pretty easy case for OSHA to make, that discipline is retaliation for the reporting the injury. And then last but not least, that employers were required to update their internal injury reporting policies to remove, quote, unreasonable elements. So anything that would discourage employees from reporting injuries or illnesses. And so that's something that's kind of vague, or at least some employers have struggled with. So moving to the next slide, kind of dig into that a little bit and talk about what that means. So one of the things, and Rich, I'll ask you about this in a second. I know, or at least if I recall, with the Fairfax memo, that a couple of the issues that you focused on dealt with disciplining employees for late injuries or late injury reports, as well as for violating vague work rules. And it's not a big surprise to me that the agency in particular takes exception to violation that is issued for failing to work safely, failing to maintain situational awareness. Just last week, a client sent me a draft response to one of OSHA's phone and fax investigation requests, and when I saw that in the conclusion, I kind of put my head in my hands and I thought, well, we've got some work to do, because that's not going to fly if we send this into the area office and just basically say, well, this employee was not maintaining situational awareness when he reached into this piece of equipment and his hand got caught and he lost the tip of his finger. What happened to that point? Obviously he was not paying attention, but why wasn't he paying attention? What was there a specific rule, training, some process, some written procedure that he was supposed to be following, but he didn't? So Rich, maybe you could talk a little bit about those 2 prongs and from your time at OSHA, why they were a concern for the agency.
Well, both of them were, excuse me, this came out in the last administration, and it quite frankly is tied to that 2013 memo. And there was an issue, and this with the late injury and illness reporting. I mean, the key to this one, and it's really a training issue for employers to instill, in my mind, on the employees. But oftentimes, an employee may, bump themselves or fall or wrench their back, and while they're there, they don't feel any sort of discomfort, so they don't report anything. Then they go home, and the pain and everything hits them later that night. So they come in the next day, or they come in the following Monday if it happened late in the week, and then they report it, and the employer turns around and penalizes them for reporting it late. One of the things that needs to be done, the employees need to know, is that, if you think you might have hurt yourself, then you need to report it. The other side of that is this legal requirement requires that, prevents employees or employers from taking action on an employee that reports something late, because oftentimes they just don't know. So it's kind of a dual effort there. On the vague work rules, and you've got a couple of great ones here. Work safely. I've seen work rules where people have been disciplined that say, be careful at work, or watch out where you step. And I'll give you just an example. This was actually before the standard, but it dealt with lead. Their work rule was that they're supposed to keep the break room clean. Well, there's no instruction what to do, and the employee that was in charge of keeping the break room clean thought that meant, emptying the ashtrays and taking a dry mop or whatever and sweeping off the tables and the floor. Well, OSHA got called in, and I happened to be the one called in to do it because, they had about 40 people at that place that had really high blood leads, and yet all the airborne lead levels were low. And it all traced back to the workroom. They were getting it through ingestion. Well, then, of course, the employer disciplined the employee, and the employee filed a whistleblower complaint. The employer disciplined him because the employee wasn't keeping the workroom clean. And there was never any sort of instruction. So you cannot have these vague work rules that you fall back on to discipline employees. You do have to spell things out. Back to you, Aaron.
Thanks, Rich. And then moving on to just very briefly, the next slide on drug testing. I don't want to spend a lot of time on this. We've done entire webinars on this topic, and we've really dug into the details. But the same general principles apply here. What OSHA has historically looked at, and it's vacillated a bit from one administration to the other. It's a little bit less of a focus now, but is whether you are using or there's a perception that you are using drug testing to discourage or dissuade employees from reporting injuries or illnesses. So what the agency has historically looked for employers to do is do an assessment of the incident, test those people whose impairment by drugs or alcohol, if impairment could have played a part in what happened or their role in the incident. So somebody the person who's driving the forklift that goes out of control or careening around the corner, the person who is operating a crane or what have you. If it's an innocent bystander who is minding his or her own business, who was in the right place at the right time and doing what they were supposed to be doing, then you're generally not going to test that person. Similarly, with people who report sort of the repetitive stress or strain injuries, it's going to be harder, not necessarily impossible, but harder to make the case that drug use was a precipitating or cause of their injury. So it's not entirely impossible in certain circumstances, but obviously a very much tougher argument to make. So moving then on to the safety incentive and bonus programs. Again, I mentioned this at the beginning. This is the infamous prohibition against pizza parties. I have analogized this issue to kind of two different parenting styles. I've got 3 kids of my own, often debating what is the better way to parent. Is it discipline or is it rewarding good behavior? And I kind of looked at this memo, at least from that perspective of, OSHA likes to see systems that reward employees who participate in safety committees, who make safety suggestions, or report near misses, as opposed to disciplining the folks that taking action against things that when they go wrong. So rather than me kind of prattle on about this topic, maybe here, Rich, I'll turn it over to you as the author of, but this is the Fairfax memo. So I'll maybe let you kind of share your thoughts and maybe give us a little background on how this memo came to be, or at least what the agency's objectives were in issuing it.
Well, sure. It's this was obviously a first of its kind memo for the agency, and it was a controversial memo. And and I'll be real frank. I mean, there's certainly some of it I agreed with, some of it I didn't agree with. But the intent, I think, was good in the memo. The intent was not to have any sort of policy, procedures, incentive programs, or whatever you want to call it, in place to discourage people from participating in safety, from reporting near misses, from reporting incidents, from reporting injuries. It was supposed to encourage the agency. At that time of the memo, Dr. Michaels was the assistant secretary, and there was a real push, and he had a real strong push on revamping the OSHA Whistleblower Program, primarily Section 11C of the OSHA Act, and this was an avenue to pursue that. It didn't really come out in publication, but OSHA sort of broke down incentive programs into proactive and reactive. And I'm not going to talk about reactive right now because we'll be talking about that in a later slide. But I was trying to encourage employers to move away from the negative incentive program. And you mentioned, Aaron, the pizza parties, or the giveaway of the TV, or the extra bonus money right before Christmas, or things like that. But the intent was to move for OSHA to move employers into having positive, proactive incentive programs. The more incidents you report, the more potential causes of accidents you report. You report near misses. You report potential hazards. You report employees doing unsafe acts or whatever. That was sort of the intent of it. The memo's been canceled, and there is there's been actually a couple of replacement memos. But one of the unintended consequences of this was there a lot of if the memo was enacted and stayed in place in its full form, an awful lot of companies in the voluntary protection program would have been kicked out of the voluntary protection program, because they had these incentive programs, not just for managers, but for employees. And it created a real tug. And this memo actually started triggering the VPP memos that have come out dealing with different issues. So we'll talk later about the reactive ones. But the intent of the memo was to encourage employers through incentive programs for positive incentives, reporting injuries, reporting near misses, reporting potential accidents, reporting unsafe acts, and encouraging employees to raise issues so management can take action. So I'll go back to you Aaron on that then.
All right, thanks, Rich. And just moving on to the next slide, I just really want to focus on, so this was a memo issued, an interim enforcement memo issued in November of 2016. That is, Rich, this gets to Rich's point about the emphasis on the Whistleblower Protection Program. And the main point here, just to let you all know and emphasize that look at the remedies that are available. So if an employee is terminated, suspended, what have you, and they bring an 11C or any of the other whistleblower claims, OSHA investigates all of them under the various different laws, whether it's the Surface Transportation Act, I think it's the Nuclear Regulatory Act, about 20 something different whistleblower protections in various statutes. There is both the potential for back pay as well as reinstatement, which means that you could have the unhappy employee but vindicated employee back in your workplace. So there are real teeth to the whistleblower protections. So moving on to the next slide, and Rich referenced some of the VPP memos that came down as kind of updating / replacing the original memo. So in August of 2017, the memo was issued that, and you can kind of see how this in the next slide refines into this memo. I'm sorry, just going back to the last slide. The August 2017 memo really highlighted two types of programs that COSHOs or the inspectors should be looking for. So those programs that reward workers for reporting near miss or hazards occurring. This kind of gets to what Rich is talking about, the positive behaviors, those that reward or encourage participation in safety and health programs or incentives. But then also the rate-based programs that focus on the numbers of injuries or the rates of injuries. And I think, Rich, this is the sort of reactive piece that you're talking about. So maybe just a quick.
Yeah, just quickly. OSHA has taken a hard stance on rate-based, incentive programs. And the rationale behind this is, I'll just give you an example. We had actually a number of cases like this, but there was an incentive program that if the injuries were kept below a certain amount, by the end of the year, everyone got a bonus. Employees, managers, everyone got a bonus. And lo and behold, on December 20th, an employee did something or something happened and the employee injured themselves. And the incentive was dropped for everybody, or it was dropped just for the employee that injured themselves. I mean, that's a real negative on OSHA. So you can't have a rate-based program or one that's based on the injury and illness rates or the number of injuries or anything like that. Now, OSHA, just real quickly, did back away from that, fairly recently and said you can have a rate-based program, provided it is not implemented in any sort of manner that discourages reporting. Now, frankly, I don't know how you can do that, but OSHA did allow that. But in my mind, the only way to be safe is if you stay away from rate-based incentive programs. Right.
Yeah, and I think if you look, then moving to the next slide, that you see what Rich, what you're talking about, this October 2018 memo that talks about what are the I think the kind of the things that can put in place around it to protect or give yourself some support for those types of programs. So again, having those incentives, you're going to have a rate-based program. What do you need? Incentives for identifying unsafe conditions, these rewards that we talked about, training that is provided to employees to reinforce the reporting rights and the responsibilities, and for emphasizing the non-retaliation policy, and this is a little bit unclear, but a mechanism for accurately evaluating the employee's willingness to report. I think that's, basically if you're putting those types of items in place, that then gives you some protection to have a rate-based program, as Rich said. I think, if we have new leadership in OSHA, starting in next year, I would certainly expect to see this among many things, but this would probably be one area that I would expect to see change, and go back to a lot more scrutiny of rate-based programs. So then to the next slide, the last one I'll talk about, and just very quickly, just to kind of give you a sense, when we last compiled statistics, OSHA had issued 11 citations under the anti-retaliation elements of their e-record keeping rule. 7 were classified as other than serious, and 4 for adverse employment actions, and then 4 for maintaining unreasonable procedures for reporting injuries or failing to inform employees about reporting rights. So those are the sort of things. Certainly, the last four would be the sort of violations that you can avoid by a close reading and evaluation of your handbook or your procedures. Just a little bit of wordsmithing, a little bit of revision. So with that, thanks for everyone's patience. We hope this was helpful for you. I'm going to turn it over to Megan now to talk about employment.
Thanks, Aaron. Thanks, Rich. So you'll hear some similar concepts as we kind of move into the EEO context of having discipline for, just kind of general, non-OSHA specific performance issues or policy violations in the workplace. And so one of the things, just kind of to start it out, is, it goes without saying that discipline might not be a manager's favorite part of the job, but it can really be an effective tool for positive and productive communication with team members. And as Aaron kind of alluded to in the beginning, it's having an effective discipline program can certainly, if you do ultimately have to have a termination based on, following from discipline or coming out of discipline, having an effective discipline program can certainly kind of set you up for success on that. And so there are really benefits to both the employees and the employers. It provides an opportunity, certainly for the manager and the employee, to focus on what really matters, right? That employee's contribution and value to the team. It's also a really good opportunity to clarify what the policies and procedures mean if there's any confusion, what the expectation is of that employee. If there's any uncertainty or questions, it's a good opportunity to kind of answer any questions that employee may have or identify any issues that may have fallen through the cracks that can be addressed and kind of get the employee back on track. And then ideally, discipline will address the issue, and that'll result in happy, productive employees who stay. And if not, it will, provide support for next steps if necessary. So as both Aaron and Rich discussed, in the OSHA context, the same goes here in terms of having an effective discipline program. Consistent communication, implementation, and enforcement of the policies and procedures is key. And I'll talk a little bit more about that in a few slides, but part of what makes this so important is that the employee should know what is and what isn't permitted. And so a key part of the consistency is giving employees notice of what's expected. The second part of the key to consistency kind of comes later in terms of making sure you're not in a situation where you may be retaliating or discriminating against somebody for engaging in protected activity. Another key part is of having an effective discipline program is properly investigating. So you kind of can make a fair determination of what happened, and you can have good facts and context on which to take next steps. And then the third point is just document. It's not only important if there's a lawsuit down the line, which that is critically important, because that'll be the first question you get from the lawyers is, let us review the notes and documentation, performance reviews, any disciplinary actions that were taken. And that comes when there is a claim, when a claim or a lawsuit has come across my desk. But even before that step, you want to document, because with a given employee, you want to have a record of what happened. And certainly there could be situations that, something is said to an employee out loud, there's no record of what was said, and then maybe down the line, months or even years, you don't know that that issue was addressed already, and it can make it difficult to have kind of a clear response to that employee and a clear record of what happened. So just taking as an example, what you might do with an employee who, say, violates a work policy or procedure. You have a written handbook that's shared with all the employees when they start, or you have, your anti-harassment policy that you share with employees during required trainings, and you have a violation. So, again, that first step is really that communication of the performance expectations. Just like it doesn't do any good for a safety policy to be written in a binder somewhere that nobody reads, it doesn't do any good for a policy to exist if the employees don't know about it. And then if something does happen, you'd want to investigate the misconduct. You'd want to talk to witnesses. You might want to review, records if anything's on point, and figure out what happened. Then you'd want to discuss the conduct with the employee, but certainly want to give them an opportunity to be heard on the subject and see if there's, if there's more to the story, if there's something else going on. And then in terms of taking disciplinary steps, again, consistently enforcing the discipline. So if you have employees engaged in the same conduct, that's treated the same. So the example that was given earlier, if you have, a really all-star employee and they violate a policy, you don't want to have a situation where you don't discipline that employee, but then an employee who does the exact same thing and they're, written up for it, or have an even severer consequence for it. That's certainly the kind of situation that you want to avoid. So similarly, if you have an employee, let's say they didn't necessarily violate a clear policy or procedure, but they are not meeting expectations. So how might the kind of steps of an effective discipline program look in that context? You'd want to objectively evaluate the employee's job duties. What is expected of them? What are they supposed to be doing? And then how are they performing? Tools for effective performance reviews, certainly annual performance reviews. And even if you're outside of let's say an annual, regularly scheduled annual performance review, there's certainly nothing stopping you from having perhaps a less formal but still well-documented conversation or counseling with the employee to go over job performance. You'll then, of course, create a written record, and even if you have a low-key conversation with a person face-to-face, doing a follow-up email or even a memo to file so that there's a record that the conversation took place is really important. And then, of course, depending on what the performance issue is, you can consider tools to move the employee towards a path of correction. And I'll discuss some of those in a minute, but consider a performance improvement plan or what other steps could be taken to give the employee an opportunity to improve. And then still key to handle similar performance issues with other employees at all levels of the organization in the same way. So certainly, some of this depends. What you do in response to an issue with an employee certainly depends on the conduct and the context. And you may be able to achieve your goals through a less formal process, or if you don't have, a clear written progressive discipline policy, you may have a different way of addressing it. But there certainly are tools you can implement to address these things. A progressive discipline policy is exactly what Rich referenced earlier, where there's clear delineated steps, sometimes outlined in a handbook or otherwise in a written policy that's communicated to employees saying, you know, there'll be a verbal warning, a written warning, last chance, whatever the policy is. And these are really designed to have, you know, a series of graduated steps to deal with the performance or conduct issue with the goal of correcting the issue at the earliest stage. Something like a performance improvement plan might be a great tool to use if you have a real commitment to help the employee improve, and you can specifically identify goals or kind of steps the employee can take to improve behavior-related concerns or other issues. These can be really helpful because, you know, there's kind of a team approach to the issue, and the employer has, you know, the employee's support in trying to improve, and it can sometimes be seen as a less kind of draconian step. It's not necessarily, you know, the first step on the way to a termination. It can be a very positive tool. And at the same time, if the employee, you know, isn't able to comply with and follow the performance improvement plan, it can support a termination or a demotion or some other action. And then finally, last chance agreements. These can, you know, they're also referred to as, you know, a final written warning. They can be part of a progressive discipline policy, or if a workplace doesn't have a progressive discipline policy, it can be used independently to say, you know, here's what happened. This behavior is not going to be tolerated. If it happens again, it will result in termination. And the key there, of course, is to comply with your own last chance agreements and not to have a situation where the employee engaged in the conduct one last time but wasn't terminated for it. And the reason there is that, you know, that can create an issue for an employer if they didn't address an issue that needed to be corrected, and they kind of allowed the conduct to continue without taking any necessary action. So I mentioned earlier that there's kind of two key reasons why consistency of enforcement of policies is so important. And the second prong of that is that employers always have to be cautious in assessing whether a decision to terminate, discipline, or otherwise could be considered unlawful. And the issue with inconsistent enforcement of policies is that it can become easy for example, an employee to tie the disciplinary action to a discriminatory or otherwise protected act that employee engaged in. So the next two slides kind of provide all of the various reasons why an employer might face a claim if it disciplines an employee under certain circumstances. The first is certainly discrimination based on any protected class. And depending on where you have operations, you'll want to pay attention to what is protected in the state in which you're operating. Some states are more protective than others. This is just a short list, but certainly if you, let's say you're only disciplining employees in a certain category, that's certainly something that is going to give rise to a claim and could be problematic down the line. Another example is retaliation for engaging in protected activity. This was mentioned in the OSHA context. An employee complains about workplace safety and then they're disciplined. In the EEO context, this could be, this comes about in a variety of contexts. It's sometimes related to discrimination, retaliation, harassment claims, often work hand in hand. So the example of workplace harassment, let's say you have an employee who makes a complaint of workplace harassment or participates in an investigation about workplace harassment, And then next thing they know, they were transferred to a less desirable office location. And now they've tied that adverse employment action to their participation in the workplace investigation, or their making the complaint in the first place. Another kind of action to pay particular attention to is an employee who takes or even seeks to take protected leave. Protected leaves could exist under the Federal Family Medical Leave Act, or even federal or state disability leave, certainly pregnancy and parental leave protections, military protections, sick leave, and even in the age of COVID, there are some protections for employees seeking family or sick leave related to COVID. And in fact, we've already seen some claims popping up alleging firings based on an employee's need to, for example, take leave to care for a dependent due to COVID-related school closures. One note I'll also make about sick leave is that some state and local sick leave ordinances specifically limit an employer's ability to discipline employees for unscheduled absenteeism or tardiness. Of course, provided that those absences are covered by the protected sick leave policy. So sometimes I'll see policies in handbooks that provide for kind of automatic termination for no call or failure to show up to work. And it's important that if you're operating in jurisdictions with those protections for sick leave, that your policies for absences and tardies don't violate potential sick leave policies. I recently got a question of, well, what if an employee is, absent every Monday or is late every Monday? It may take some investigation or some discussion or just some general awareness that that employee may have a standing doctor's appointment. And sometimes in larger organizations, maybe that employee's, maybe that one of that employee's supervisors, if you're supervised by multiple people or you have a direct supervisor and a higher level HR person, maybe the HR person knows about it. And so they wouldn't retaliate against you for it or ding you for being late when you have a doctor's appointment, but maybe your direct supervisor doesn't know that and they ding you and unintentionally violate that policy. Also, an employee seeking to enforce wage rights, engage in union activity, or engage in any other protected activity. So this is certainly a lot to think about, but the key takeaway here is just to kind of go through a checklist and be aware of these issues when potentially disciplining an employee so that it takes part and it plays a role in the decision-making process. So this kind of plays into the topic of conducting effective investigations. And the first point here is that not all situations are going to warrant having a third-party investigation or even internally a kind of what you might think of a full-blown investigation with lots of interviews and time-consuming. But depending on the situation, a full-blown investigation and even an outside third-party investigation can be really helpful in protecting against claims of discrimination or retaliation because it provides an independent explanation for why the disciplinary action was taken and can provide some protection against a claim that the decision was made based on protected activity or discriminatory or retaliatory bias on the part of the decision maker. The other thing to note is that even where a person who disciplined an employee themselves acted with proper lawful intent, if the decision maker acted on information provided by someone else, say another supervisor, and that other person acted with discriminatory intent, then that can influence the decision and there could still be a potential claim. So if you have really tricky situations, and in such cases you might already have employment counsel involved, but in those tricky situations, it's particularly important to think through whether a third-party investigation would be helpful.
Yeah, and Megan, I would just add that along the lines of what you're talking about, what I look for and what can be really helpful in defending discrimination claims when if the decision maker is also the witness in essence, or if it's the manager who evaluated the performance, saw the misconduct, reached the conclusion, is then imposing the discipline. As you can see, it's kind of a closed loop, and there's really no oversight. So you can kind of break that causal connection or that intent chain by having someone else then conduct, whether it's an investigation or really just a review with unbiased eyes. So in those instances, I think it's a great practice, assuming you have the bandwidth to do this in a large enough organization. Rather than the manager, he or she passes along what they have observed or what they've witnessed or what they've learned about, and then hands it off to somebody else. And that person then basically starts from scratch, taking the materials that the manager pulled together, but then re-interviewing everybody, talking to the employee, talking to the witnesses, reviewing the documents or whatever, and then makes a conclusion, and that then breaks that connection that Megan's talking about. Not always possible, I understand, but can be a great way to further protect the organization.
Thanks, Aaron. I'll just close on just some final thoughts before passing it over to Mark. Additional considerations to keep in mind when conducting investigations is, they should happen as soon as the issue comes to light, so that memories don't fade. They should certainly be fair to all parties, that including potentially the accused. They should be thorough so that all of the information is gathered, so that a determination can be made. And then one final thing to just consider is if there's any restrictions on who may conduct the investigation. I at least know in California that certainly internal HR, in-house counsel certainly can handle investigations, but if you use an outside investigator, there are specific rules that restrict workplace investigations to either a state licensed private investigator or a state licensed attorney. So outside HR consultants who are not licensed attorneys and not licensed private investigators cannot legally conduct an investigation in California. And if you're going to go through the whole step of having an outside investigation, you want it to at least be a helpful tool that you can use in a claim. And if it's an unlawful investigation, it's going to be hard to use to defend against the action. And with that, I will pass it over to Mark.
Thanks, Megan, and thanks, Aaron, and thanks, Rich. I know that we perhaps have got just a bit over, so I will be efficient in these last few slides, dealing with discipline in the unionized workplace. Some of this may seem familiar to those of you who have paid close attention to the first presentations. But like Aaron mentioned at the beginning, discipline in the unionized workplace can be an entirely different kettle of fish. Certainly business owners and employers feel, sometimes rightly so, that unions interfere with the efficient running of their business, and perhaps nowhere is this more evident than in the realm of employee discipline. Let's start with the collective bargaining agreement. I've picked just a few sort of highlights here. I'm not going to touch on every single aspect, but certainly the collective bargaining agreement sits at the heart of the relationship between the union and the company, and thus the employees. Sets the basic rules. One thing that I would point out here is your supervisors should be very aware of the CBA and what it contains. I've had a lot of instances where you end up in an arbitration or some sort of hearing, and the supervisors are not fully conversant with the terms of the contract, and that can make a big difference. So one thing I'd point out is to have your supervisors review the CBA at least annually, and probably even semi-annually or quarterly, just as part of their regular review. They should sit down and just read through the CBA. You'd be surprised what sort of issues can come up from that. Obviously, though, that's the starting point for any discipline in the union environment. It controls all the substantive issues, basically the simple terms and conditions of employment, wages, benefits, contribution levels, things like that. But it also controls scheduling and overtime, and many issues like seniority control those things. So it's good to know. You can also should keep a running list throughout the term of the contract of all the issues that come up during the term of the contract. This is a good tip for negotiating the next contract. You can go through call it your contract file, and throughout the term of the contract, when there's indications that the company and the union are not on the same page with regard to the interpretation of the contract, or there's gaps or holes, you can address that in the next negotiations. Keep the grievances, any unfair labor practice charges, things like that. One note about past practice, unions often claim past practice when there's no clear right under the CBA. And so if there are things that are going on in your workplace, your supervisor should be aware of that and ensure that you're okay with it, lest you end up being faced with a past practice claim. That's all I'll say about that. The procedural issues can be pretty important under the CBA as well, and you need to really pay attention to those when you're dealing with discipline. Unions and sometimes employers often ignore deadlines, or it's sort of understood that the deadlines maybe don't apply. Well, I wouldn't fall into that trap. If you want to rely on the deadlines, you need to enforce them all along. Most CBAs say that you need to engage in grievance meetings or different steps. If you don't raise issues, procedural or timeliness issues at the first opportunity, some arbitrators have held that you've waived them. Things like that really need to be taken care of right at the outset of considering employee discipline. Also, pay attention to when items drop off of the CBA. Many times, discipline issues, CBAs will have clauses that say that discipline issues no longer can be factored into determinations made with respect to an employee past 12 months or 24 months, something like that. That's often true with attendance, sometimes true with other issues as well. Let's talk about the duty to bargain pre-contract. And you might be saying, well, what are you talking about there? Well, if there is no CBA, this would be in the situation where an employer has been recently organized but has not yet negotiated or signed a contract. Well, for nearly 80 years, the National Labor Relations Board observed the rule that newly organized employers had no obligation to give a union notice of or any sort of opportunity to bargain over discipline before there was a contract in place, before they had negotiated a contract and signed one. But in 2016, that all changed when the Obama era labor board issued this case, Total Security Management, which held that employers did have to provide notice and an opportunity to bargain before disciplining employees before there was a contract. Like I said, that overturned 8 decades of precedent. It was a big issue. And just this summer, in fact, just a little over a month ago, in June, the newly constituted labor board reversed the Total Security case and restored the prior 80 years of precedent that employers did not have a duty to bargain over serious employee discipline issues. So be aware of that. If you are newly organized, that may flip back the other way when we have a new board, as a lot of other issues have. Let's talk a little bit about what happens when the collective bargaining agreement expires. Post-contract. So many of you, certainly the union employers among you, know that after the contract expires, you have a duty to maintain the quote status quo. That usually encompasses your contributions to health insurance and pension, your wages. Substantive terms continue on. There was an interesting case, I won't get into it too much given the time, but this Next Star Broadcasting you might check out if you've had a right to act unilaterally. The new board also held that you as the employer had the right to act unilaterally with regards to the contract, and that was embodied in the terms of the contract. The new board has held that expired with the contract as well. So if you want to retain the ability to act unilaterally, which has been secured under the contract, you want to make sure that language survives the expiration of the contract, and you want to negotiate that in there. But most items do expire with the CBA. And one thing that I should point out particularly is the arbitration clause. That expires with the contract, and you have no obligation to arbitrate if the dispute arose post expiration. However, you do have a duty to process the grievance through the earlier steps, and so you want to make sure that you do that, but you have no duty to arbitrate. Let's look a little bit at the just cause standard, which is the basic end-all be-all of discipline under almost every CBA in a union environment. Just cause is, I think it's been in every CBA that I've ever seen except for one, and I was surprised that I saw that one. But most arbitrators apply it across the board. It's basically just a fairness, and this goes back to the comments I made about your supervisors earlier, and how supervisors should be aware of what's in the contract and what the terms are and know the rules. Well, you also want your supervisors to be honest and clearly communicate with the employees, to be open, to foster respect, to treat people fairly. And that certainly unions would say that goes to the just cause standard. And I've listed some questions here that you could throw out as to whether you had, quote, just cause. Obviously, this is different from at-will employment, which pertains in non-union environments, absent discrimination or statutory protections. Most places are considered at will, but in the union environment, you need just cause to discipline. So these questions pertain to those determinations. Did the employee receive notice? Was the investigation fair? Is the company's position reasonable? Has it been consistently enforced? Is the discipline proportional? Things like that. You need to be clear. And that's just good advice across the board, but certainly in the union environment when you have a written CBA. Let's move on and talk quickly about Weingarten rights. This is another issue you should be aware of. Weingarten rights are so-called rights from a case called Weingarten that was, I can't remember if it was, I think it was in the 1970s before the Supreme Court. How the union employees have rights during investigatory interviews. Basically, if you're going to conduct an investigatory interview with a union represented employee, you need to follow the employee. If the employee asks for union representative during the meeting, you've got three choices, and I list them out there at the bottom of the slide. You can grant the request and stop questioning the employee, schedule a meeting, or wait for the representative to show up if they're on site, if it's a shop steward or something. You could discontinue the interview, or you could offer the employee the opportunity to continue with the interview or have no interview at all. And you could say, well, you know, we want to interview and find this out, but we're not doing it with the union steward, or we're not waiting. And so you can either have no interview and we won't know your side of the story, or you can go ahead with the interview unaccompanied, and the employee can make that choice. Just know this, we'll sum up this, that you can't discipline or discharge a union represented employee for refusing to submit without their representative to an investigatory interview if the employee reasonably believes that discipline may result from the interview. Let's go to the next slide, please, and talk just a bit about conducting interviews in the union environment. Obviously, this comports with what happens in the non-union environment. You want to gather statements from the witnesses before you impose the discipline. So you want to investigate and get the facts. However, in the union environment, there's another case that has established another set of rights for employees. This case was called Johnny's Poultry and was decided by the NLRB in 1964. I listed there. There's 3 requirements for this too. And it generally is when you're preparing for an unfair labor practice hearing, most employers provide these same warnings when preparing for an arbitration, although I think that it's not technically necessary. But you need to communicate the purpose of the questioning to the employee. You need to assure him or her that there will be no reprisals and get their participation on a voluntary basis. As I say at the bottom of the slide, it's a good idea to get the statement, to give this statement in writing, and there's so-called Johnny's Poultry forms all over the place. If you need one, let us know, we can get it to you, but it's just a form that you present and even have them sign it before the interview, just so that everybody's on the same page. Let's look here at the last slide, which also deals with conducting interviews. This sort of goes along with the Johnny's Poultry rule. You should not maintain a blanket rule requiring employees to assist in workplace investigations, as they have. It's not clear the right to compel, but certainly with the Johnny's Poultry warnings, employees can refuse to participate. You can request their participation and not state whether it's voluntary or mandatory, and employees may go ahead with the interview without recognizing that distinction. But in any event, when you're conducting these interviews, you want to avoid any sort of unfair labor practice charge or any leanings that way yourself. So no interrogations, no threats, no coercion. Don't ask the employees about union views, their activities. You basically want to don't go beyond really what's needful for a clear and legitimate purpose to achieve it. Don't pry into union matters. Ask more objective questions, not subjective. Ask relevant questions about the issue being investigated, and don't really go beyond that. That's all I'll say about conducting interviews. And again, these rules that I've spoken to, these tips, these hints don't encompass every aspect of discipline in a union environment, but they do represent some of the icebergs to avoid. I would just end by reiterating, you want you and your supervisors to treat people fairly. That's really what you want. Don't forget, even in a union environment or non-union environment, relationships matter. And so treating people fairly, fostering respect, being clear with your communications, being honest and open, treating people fairly, that's really what you want, and that's what you really have to do to properly discipline employees in the union environment. With that, I'll check back with Megan and Aaron and Rich and see if there's anything else they would like to add or sum up or respond to. And thank you for your time. Aaron and or Megan or Rich, do you have anything to add?
Yeah, just real quick, Megan, if you can just zip through the last couple slides, just a little bit, some few other things going on right now in the world beyond the intricacies of employee discipline. If you have any questions about COVID-19, the pandemic, check out we have a task force, and we put together a detailed list of FAQs with some pretty or extensive list of FAQs, detailed information on a variety of topics. We also, if you to the next slide, we've got our two blogs, the OSHA Defense Report and Employer Defense Report, with a lot of information crossed with the COVID resources, but also a variety of other different topics on safety and health, on discrimination, labor and employment. So check those out as well. We've got our two webinar series that I referenced, both the OSHA webinar series as well as the labor and employment webinar series. I already talked about next month's programs, and looking ahead. I think in October we'll be talking about looking ahead at the elections as part of the OSHA webinar. So lots of information out there for you all. I know that we ran long, so to the intrepid souls who stuck around for the whole thing, thank you. And we did see some questions come in the interest of time and respecting everybody's busy schedules. We will get back to you all individually. I think a lot of the questions are fairly specific. So we look to hear from one of us speakers in the coming days with some thoughts on your questions. With that, thank you to everybody for joining us, and we look forward to you hopefully logging in and listening to future webinars. Thanks and have a good week.